Hello to everyone here in the room, and hello to those of you joining us in Zoom land. Welcome. My name is Derek Haley. I am a faculty member here in the Ontario Veterinary College, and I have been an associated faculty with the Campbell Centre of the Study of Animal Welfare ever since I came to Guelph, which is a while ago now. And it has been my pleasure since the start of the semester to be chairing our weekly meetings that we hold here at Guelph related to animal welfare. Every once in a while, I guess at least a couple of times each semester, we have a special seminar that takes place, and we are excited and have been looking forward to today as one of those special seminars. Today's speaker is Dr. Shane Bateman. He is a faculty member in the Department of Clinical Studies here at the Ontario Veterinary College, and he is trained as a veterinarian. He has a DVSC degree, and he is actually a diplomat of the American College of Veterinary Emergency and Critical Care, if I have it stated correctly. Yes, and most recently, Dr. Bateman in 2022 completed an MSc degree at the University of Florida while he was on sabbatical. And that graduate degree is in veterinary forensics science. And so we all hope that that has helped to pull him even closer to the work and to the mission of the Campbell Center. He has recently received some funding from the center for some of the work that he's doing. And we're really pleased that he is willing to come and talk to us today and tell us a bit more about that. And so as you can see from the title being shown in his lead slide, the title of his talk is From Barn to Courtroom: How Veterinary Forensic Science Shapes Animal Welfare Outcomes. So, Dr. Bateman, we look forward to your talk. And again, thank you for coming. And please help me welcome Shane.
Good afternoon, everyone. Thank you, Dr. Haley, for such a kind and gracious introduction. I have a complicated career that's gone a lot of different directions, and this is sort of the most current iteration and the things that are keeping me energized and fascinated about the work that we're all very focused on. So, I'm giving everyone fair warning that some of the content in today's talk could be disturbing for some of you. We will be talking about violence against animals, potentially sexual abuse of animals, and interpersonal violence. So I ask and invite all of you to take care of yourselves and each other. There are a number of resources here if anyone should need additional support. Dr. Haley's alluded a little bit to the complex path that has brought me here. And so perhaps I'll just start off with a little bit more of a personal story. I never intended in any of my wildest dreams to be involved in veterinary forensic science. I'm sure like many of you who are aficionados of CSI and similar programs on TV, that we found them really interesting and, enjoyed them for everything they had to offer. But at no point ever during watching one of those shows did I ever think that I would be standing here talking to anybody about forensic science. That changed for me in 2018 when I was at a conference hosted by Humane Canada, an organization that I dearly love and serve on their board of directors for currently. On the violence link. And one of the keynote speakers at that conference was Dr. Melinda Merck, who is sort of the grandmother of veterinary forensic science in North America. And she had a really important call to action for the interdisciplinary crowd that was in the room that day. And that if we want animal welfare to look better, to have different outcomes, then everyone in the room, every discipline, every person has a role to play, and we all have to work better collaboratively in order for that to take place. She especially called out veterinarians in the room, so I was hiding behind my name card, to say that we are really behind. There's a lot that we have to offer to this process, and yet we are often abrogating our responsibilities to our patients and to the community in general. And so that really hit home. I thought very carefully about the power and privilege that I have as a faculty member, and my voice to students and academic circles was one that I felt I could use to bring some of these issues to more attention and ultimately, hopefully, accomplish better things in the future. So that was how I sort of went into that work, completing the degree in 2022, and since then have really been quite focused on how do we incorporate some of these kinds of issues and principles and the academic discipline of veterinary forensic science into the curriculum to help student veterinarians to do their job better, to fulfill the needs of society more effectively. Once I felt like I had some of that underway, I've started to branch out and to network within the law enforcement community, within the legal community, and hopefully within, at some point, the justice circle, to again highlight to all factors or all components of that system what veterinarians could be doing to help in animal cruelty investigations and prosecutions. So what did I learn when I went to school? Well, I learned that forensic veterinarians are important. The additional training that we receive as part of that degree really involves anywhere where animals may intersect with the law. That most commonly probably comes to mind as being criminal matters, but it could also involve civil matters, where, for example, a producer who's had a lightning strike and has launched an insurance claim, which has been denied by the insurance company. A forensic veterinarian could be involved in working either for the producer or for the insurance company to try to help understand what the evidence could tell us about what may or may not have happened. We often aren't necessarily on the front lines of investigations, but are typically approached by law enforcement or others who have a stake in the matter to support those investigations. And our role in that is to ensure that evidence that is gathered meets the needs of the criminal justice or the civil justice system. And we utilize our expertise and training, especially to support those processes. In particular, where we can be especially valuable are investigation of very complex or large-scale animal cruelty or neglect investigations. So, for example, hoarding or puppy mills, or other situations where there are a large number of victims and a mountain of evidence that needs to be appropriately collected in those circumstances. We also support the criminal justice system as part of prosecutions as expert witnesses, being called into the courtroom not to serve the defense or the prosecution per se, but as experts who have valuable opinions, insight, and training to serve the court to ensure that the people who are deciding whether or not someone is guilty or innocent have information available to them from an expert so that they can most effectively make their decisions. And as I mentioned, my job I've seen as providing a lot more outreach to various different communities. And in part, thanks to the Campbell Center, this past summer, we received a grant to develop an educational program for practicing equine veterinarians. Horses, because they're in between most of our laws in many circumstances, they're not necessarily seen as companion animals by some laws, but they're seen as agricultural animals by some laws. And so often the complexity of the legislation that covers their well-being is not very helpful. As a consequence, equine veterinarians as well are often unwilling to get involved in some of these situations. And so this educational effort, again, through Equine Guelph and the support of Gail Ecker, who I note was on the Zoom land today. Thank you, Gail, for being here. So we built a 1.5-hour webinar, and we had hoped to deliver a one-day workshop to practicing equine veterinarians. Unfortunately, despite a really intense marketing and communication effort, only 5 veterinarians attended our webinar, and we only had 1 paid attendee to attend the workshop. So as you can probably tell, I don't give up easily on a lot of things. And so we've begun to sort of rethink how we try to approach this, and thinking of additional places in the future where we might achieve greater attendance and participation by practicing equine veterinarians. Pardon me. The key skills that veterinarians trained in forensic science will involve, again, our advanced recognition and documentation of what we term non-accidental injury. So these are all of the intentional acts against animals that can cause injury. We get involved, no thanks in part to my very talented forensic pathology colleague, Dr. Emily Brower, who's also here with us today, whose work on deceased animals really has become very instrumental in so many successful prosecutions in our province. I'll be highlighting one of those in the talk a bit later. And again, as I mentioned, our expertise in helping with large-scale investigations such as hoarding or neglect, potentially even institutional neglect situations, as again, not so often in Canada, but certainly we have the capacity and training to investigate animal blood sport activities. Investigation, which can be very complex and challenging, of animal sexual abuse issues, and especially, again, evidence collection, expert opinion reporting, writing reports, etc., both for during the investigation as well as once these cases reach the court, potentially, where we may provide expert witness testimony in the court. So it's really critical, and veterinarians, I think, have really unique skills to collaborate with all of those different agencies to, again, assist in the work of protecting animals and ensuring that animals injured are recipients of justice at the end of the day. So if we take a little tour of the current laws that govern this work in Canada, let's think first about what is a crime. And cruelty to animals has been described as a socially unacceptable behavior that intentionally causes unnecessary pain, suffering, distress, and/or death to an animal. That's an old definition, but one that I think still holds very true for the work that we all do. Again, our animal cruelty laws often include the terms pain, suffering, and distress. And it's important to recognize that how the law defines these things is often different than how welfare scientists and veterinarians define these terms. What we really want are experts like myself and others who can come into the courtroom and help define or modify these legal definitions to ensure that they are more aligned with our modern concepts of these kinds of principles. So the Criminal Code of Canada is where most of our most serious animal crimes in Canada are defined in these sections 444 to 4447.1, and then a new provision in section 160 that describes animal sexual abuse, sadly still called bestiality, even though that is an outdated term and no longer used in routine forensic work. You may be interested to know, and probably a number of you already know this, that this section of the criminal code is actually in the property crimes section of the code, which is problematic when we think of animals as being sentient beings who can think and feel and experience emotion. It's pretty hard to believe that in a country like Canada, that they're still defined as property. And as a consequence, there are a lot of implications to that in how, when animals are seized in an investigation, how they must be treated because they are a piece of property that has to have a chain of custody that follows it in order for them to be appropriately managed in the criminal code or the prosecutional system. So you could laws at those links if you were interested. How many people and have not been updated since then? There have been modifications and amendments to the criminal code in 2018, 2014, and again in 2021 that have increased the penalties for committing one of these crimes, but the actual crimes themselves and the statute related to that has been needing some updating for quite some time. The language that's in there is pretty reflective of 1892 and not modern how we think of these things in 2025. The criminal code is a more difficult statute to prosecute under, simply because the criminal code requires that the Crown prosecutor not only prove actus rea, which is the act of committing the crime, but also mens rea, that you have to have the intent of committing that crime while you are completing the act. And as a consequence, that holds an additional prosecutorial burden for the Crown in most instances. The fines and punishment under the criminal code have been improved, but again, when we compare those to some of the fines and jail time available under the Pause Act, for example, they're still not quite the same. Prosecutors can use both the criminal code and one of the provincial statutes in Canada and sort of see how that unfolds in the multiple different court actions that can proceed. But currently, most of the serious offenses in Canada are typically using the criminal code for their prosecution. And one of the reasons is, again, not necessarily because of the punishment, but because of the unique nature that can be administered under the criminal code compared to provincial statutes. Under the criminal code, we have a lot greater flexibility to compel restrictions and orders. So for example, let's say you're a puppy mill person in Ontario. You're charged under a provincial act. You don't obtain a criminal code violation, and therefore your activities are not reported across Canada. You pick up and decide to move your operation to Quebec, set up shop. No one in Quebec will ever know that you had an action against you in Ontario. Whereas under the criminal code, when there's a criminal code conviction, that information is now available to all police services in Canada with our national crime database. And therefore, it's much easier to compel animal owning bans, for example, when there's a criminal code conviction. We can also compel people under the criminal code to undergo anger management or counseling. And these, again, are not things that can be compelled under provincial acts. So again, in each province in Canada, in addition to the criminal code, there is typically an animal welfare piece of animal welfare legislation that tends to focus a bit more on some of the aspects related to neglect and standards of care, what we expect of people who are looking after animals. As many of you will be aware, this act was introduced in the fall of 2019 when a constitutional challenge arose against the previous legislation, the OSPCA Act. And the provincial government elected not only to appeal the constitutionality of their previous act, but introduce an additional act in the meantime. As a consequence, that act came into being in 2020, and it ended the involvement of all charitable animal welfare societies in the enforcement and prosecution of animal cruelty and abuse in Ontario. So while all of those organizations still exist, they do not have the legislative ability to participate in investigations and prosecution. That function now rests solely with the employees of the Ministry of the Solicitor General who are hired as animal welfare inspectors in Ontario, in addition to the provincial, any police officer who's designated as a peace officer in Ontario can also enforce the PAWS Act. So when you have a concern in Ontario, you are requested to call the dispatch number, which, while it operates 24/7, the government employees that are enforcing the act may not be working 24/7. And as a consequence, after hours or on weekends, this may not be a time where animals are as well protected as during business hours. And so it's great to know that police officers in Ontario have the ability to prosecute and assist under this act and may be helpful in these off hours or emergency situations. What we're seeing right now in Ontario is that a lot of the major police forces around the GTA and Hamilton, Greater Hamilton area are taking this responsibility much more seriously and are bringing in some of these more difficult, challenging criminal code cases, investigating and prosecuting within their service without necessarily involving the Provincial Animal Welfare Service as directly as they might otherwise have been. So as we reflect a little bit on that, again, the legislation in these areas is challenging. How do veterinarians accept, how do they deal with their sort of mandated responsibility to report suspicion? In every province, there is a mandated responsibility. So by law, veterinarians who see or are suspicious of animal maltreatment are required to report under the law. We don't have a lot of great research, but the research that we have available to us that says Canada is not much different than many other jurisdictions where veterinarians commonly report in a survey situation that they're quite confident that they've seen animal maltreatment in their career, but they report it only around 30 to 40% of the time, which is concerning. There are probably a lot of reasons for that. Certainly, organizations like the Canadian Veterinary Medical Association continue to remind veterinarians of their ethical, moral responsibility to do so. But there are a lot of reasons why veterinarians may not understand this and or act differently than what we would expect them to act in these situations. A big factor is that as part of our training, we are diagnosing things all of the time. That requires quite a high level of proof before we make a diagnosis. We don't just sort of say, well, I think, or I'm suspicious this might be what's going on, therefore I'm just going to move off in that direction. And so I think that plays a role because we assume that the same thing is required of us in this situation, when in fact that is not what the law requires. The law requires that we be suspicious and that we don't necessarily have to have proof. In the criminal justice system, the triers of fact are the only people who decide whether someone is guilty or innocent. And that is a judge or a jury in the criminal justice system. Veterinarians again think, oh, I don't want to disrupt someone's life. I don't want to take the chance of reporting something that might not have happened if I'm not more certain. Okay, so that's a big motivation for people. Again, the laws are confusing. Who am I supposed to report to when? Oftentimes, again, I think collectively, we think something serious has happened. We make a report, and then we never hear of the outcome. We don't know whether something did or didn't happen. And I think we all have the perception that oftentimes things that should have been prosecuted don't get prosecuted. And that's a real failing of our system, but something that I think we're trying to address going forward. They're worried that their practice or their reputation may suffer and that they may be exposed to some litigious activity or personal liability. Again, in Canada, all of our provincial acts contain an immunity clause for any veterinarian who reports in good faith. So they can't be sued if they make a good faith report. So what I teach our students is, yes, we want to be good humans. We want to believe that most of the animals that come into our practices in our offices, what happened to them is what the owners say happened to them. But we also have to be aware that there are malicious situations where someone may not be telling the truth. And therefore, you need to rely on your instincts in the rooms with respect to how people say things, what people say, that you need to ask some more questions in some cases where you might have a concern to try to uncover a little bit more of that information. And we're looking for some very specific injury patterns that might help us to understand that this is a situation that does have an elevation of concern for us. And so whenever you're thinking of your list of differential diagnoses, you need to consider the possibility that animal maltreatment is one of those possible explanations. And then we're looking for other signs to help try to confirm that for us. When we have a serious level concern about the possibility of animal maltreatment, but not necessarily proof, that is the time that we need to report so that additional investigational activities occur. It can be quite challenging for veterinarians as well to know at what point in my examination of this patient is this me and the client having a conversation about things, and then I start to become suspicious during that, and I think, oh, I wonder if I should get some x-rays, or I wonder if I should take some lab work, right? If you start to gather evidence when you don't actually have a legal authority to gather that, then that evidence is absolutely going to be misallowed or not allowed admission into the prosecution. So it's very important that veterinarians understand when it is acceptable as part of those examinations to begin to gather additional evidence as part of that medical legal examination. So we definitely need either informed consent of the owner, voluntary relinquishment of ownership to a third-party organization like a humane society or SPCA, or a court order or other legal expectation, usually granted through the provincial animal welfare service officers or the police officers involved, who are mandating a medical legal examination of the animal. In all cases, our job is to be neutral, objective, and independent, and consider all of the possibilities in these cases. We are not working for the police. We don't find evidence to help the police. Our job is to find what we think is the truth of what may or may not have happened, or to consider the possibilities of what may have explained the set of injuries that we are looking at. We do that through collection of additional evidence, either by taking x-rays or ultrasounds or CT scans. We submit lab work to a diagnostic laboratory for evaluation. We take photographs. We capture video, especially of a number of important behavioral concerns. Again, in a number of cases now in North America, it's that videography and the video evidence that is crucial for helping a judge or a jury to understand the state of being that that animal was in when they were in the situation that they were in, to see them hair code and thin body condition, and then provided food, water, and appropriate socialization, and to see the transformation of those animals in a post video is very compelling to a jury or a judge. And therefore, that kind of evidence is really, really important. In addition of collecting trace evidence, especially when it comes to entomological, toxicological, or DNA sampling, or sadly, if a patient is deceased, then ensuring that their body has been examined appropriately to gather additional evidence that can serve in the investigation. We also learn a lot about chain of custody. It is critically important that evidence that is gathered has to have documentation of who collected it, what time, day, who was present, where it went into storage, was it submitted to a lab, in which case if I collect a deceased patient as part of my investigation out in the field and present that body to my colleague, Dr. Brower, we sign over chain of custody to her, and she now keeps track of that animal's remains for the court. The court, in order to allow evidence to be admissible, needs to see an unbroken chain of custody from the time that it was initially collected in the investigation and can be presented to the court for them to examine it. So this is a foundational principle of our criminal justice system. And as such, we have to have that secure chain of custody through the evidence through the entire process. We do a lot of documentation and, how should we store this evidence, considering that it might be in storage for a long time. We don't want the evidence to be degraded because of the storage situation. Again, it's a foundational principle that our a defense attorney who questions whether we submitted the right tests or got the right answers has the opportunity to also retrieve that evidence and send it to a different lab or invite a different expert to ensure that everyone has a fair opportunity at defending themselves in the justice system. So these are the reasons why this is such an important part of the process. And then finally, if a person who's accused decides to enter a plea of not guilty and a trial ensues, participants in the investigation, we may be called as experts to those proceedings. And again, we're not working necessarily for the defense or the Crown. Our job is to work for the criminal justice system and ensure that the people who are weighing justice in this matter have the information and expertise available to them to answer questions that the court may have. So I think we're all aware that our laws aren't great. Veterinarians haven't been doing their jobs as well as they should. Investigators may not have the experience that they should to investigate these cases. We have Crown prosecutors who have 5 murder charges and 2 rapes on their desk and don't see an animal cruelty case as something that is equally important to the community, and therefore plead those cases out, and that those people may get off a little bit more easily from some of those accusations. And so that's a system that doesn't work very well. And so my goal is to try to ensure that the laws that we do have, the Crowns and law enforcement officers with some training and education and a seasoned veterinarian at the helm of those investigations can produce different results. And so I wanted to provide a couple of examples of recent legal decisions that I think are critically important for us to be aware of because they're very profoundly influential to how we're looking at things today. The first is a landmark decision from Alberta. In the original trial was in 2020. It's been appealed twice since then. But importantly, the facts of the case are that a young man who arrived in Canada not being able to speak English from China, his family, because he was getting into trouble in China, sent him to Canada to finish his schooling. He did not speak English well enough, and so didn't finish school, and sadly was bullied pretty extensively by others in his educational environment, and ultimately he ended up in college after obtaining some English as a second language training and working in the restaurant industry. His parents in China apparently were not super nice parents, and he had a lot of corporal punishment, which included beatings as well. During the time of the incident, he was living in the upstairs apartment of a house owned by his parents, and there was a tenant in the downstairs apartment. His dog Cinnamon, a 10-month-old Siberian Husky, had defecated in the house, and he lost his temper and began beating the dog for over 20 minutes, causing severe injuries to occur. The tenant overheard this and knocked on his door in an attempt to stop the activity. He asked the tenant to go away and mind their own business, and a passerby heard the commotion from at least 100 meters away and called police, who investigated, seized the dog from Mr. Chen, took her to the Calgary Humane Society, and she was cared for by a veterinarian. Thankfully, she recovered fully from her injuries and was later adopted by another family. Mr. Chen was charged with a single count of animal cruelty under the Criminal Code, Section 445.11A, and he pled guilty to causing unnecessary suffering of an animal. In his original sentence, the Crown argued that his sentence should be 90 days of custody, which could be served intermittently, and 2 years of probation. The defense argued that his sentence shouldn't involve jail time, that his sentence should be a different form of sentence, which involves more community service, etc. And so the judge took into consideration all of these aggravating and mitigating factors in the case and ultimately decided in favor of the Crown's request. And he said that the moral blameworthiness and the gravity of the offense, which stems from the length and sheer brutality of the abuse occasioned on the dog, is of such a significant degree that the fundamental principles of sentencing cannot be satisfactorily addressed by a community service form of sentence. So Mr. Chen appealed the ruling. The original sentence was set aside, and he was ordered to start serving his community service of 1 year, the conditions of which were negotiated by the councils, respective council involved, followed by 2 years probation. This justice argued that the sentencing of a youthful first-time offender, the primary objectives are individual deterrence and rehabilitation, and not deterrence and denunciation as identified by the sentencing judge. So the Crown decided to appeal a second time. So it went to a third trial to the Court of Appeals in Alberta, who stayed the community service order and reinstated the original sentence. The accused had already served 9 of 12 months of his community service order without any breach. And the Crown was in agreement that in order to, given that he'd served most of his sentence, that they agreed that there was no point in incarcerating him further. And so the Crown, again, the judgment was his original sentence should hold, but because he'd served time, he didn't have to go back to jail. And so his 2 years of probation was started at that point in time. Really critically in the appeals judgment by the panel of judges that had seen this case, this is among the first time in Canadian animal cruelty legal precedent that there's a judgment that says, I agree that animals, sentient beings that experience pain and suffering, must be treated as living victims and not chattels or property. There can be no disputing that animals are sentient beings that are capable of experiencing pain and suffering and can be victims of violence. The animal cruelty provisions are aimed at protecting animals themselves from willful acts of violence and the willful infliction of pain and suffering. So this justice or this judgment has now been used in multiple cases since then, and has really allowed us to utilize this in sentencing and prosecutions much more effectively going forward. I'm going to summarize this case because it's quite disturbing, and I don't want anyone's lunch to be spoiled, but another recent decision in Alberta, again, against a young 26-year-old woman in Calgary as well. She was accused of between 2018 and 2023, to which she admitted a guilt of acquiring cats through Kijiji for the express purpose of torturing and killing them. She pleaded guilty to 9 counts of animal cruelty or torturing, and she ended up killing 7 of the 9 cats. And she was also charged with 1 count of threatening property damage. In 2023, Justice Dinkel sentenced her to 6.5 years. Originally, they felt that if they had added up her sentence initially, it was going to be over 12 years, but they reduced it because of some legal principles with respect to totality and because she was a youthful offender. He emphasized again the need for denunciation and deterrence. This is the longest sentence that anyone in Canada has ever received for animal abuse. And not surprisingly, the accused has been diagnosed with some pretty serious mental health disorders. And in his final remarks addressing the accused, the judge stated, "The prognosis for you is not great. Feel free to prove them wrong. Good luck." More recently, and again, thanks to the good work of our colleague in the room, Dr. Brower, in Ontario, we saw Kenneth Anthony Grant plead guilty to 5 serious offenses: manslaughter, discharging a firearm with an intent, reckless discharge of a firearm, killing a service animal, a police dog, and possession of a loaded firearm. In this case, he pled guilty, and both the Crown and defense agreed on a sentence that they felt was appropriate, which the judge accepted as part of their decision. The facts of the case are that this man's daughter was in an abusive relationship with her partner. She was fighting with the partner and was apparently threatened with a firearm in the home. The defendant, the father, entered the daughter's home in July of 2023. An altercation ensued, and the partner was shot in the head and died. Mr. Grant attempted to flee the country the following day. He was getting his things together along with his passport to drive to the airport when he was approached by a plainclothes police officer who wanted to speak to him. He fled into the woods nearby to his home, and while doing so, fired shots at the officer. The canine unit was called in to assist in the search for Mr. Grant, and as the police dog Bingo began to pick up his scent and approach him in the woods, he fired a shot at the dog and killed the dog. He was also fired on by the police and was hit twice, both of which caused serious injury to Mr. Grant. His sentence was actually handed out just recently in the last 6 weeks, I believe. Again, his sentence, because of the totality of his crimes, was reduced substantively. And he received 10 years for manslaughter, 4 years to be served consecutively for killing the police dog, and then 9 years, 9 years, and 3 years for his other crimes, which were to be served concurrently. So again, 4 years is a pretty significant sentence for these kinds of crimes. He was also issued a 10-year prohibition on owning weapons, which, you know, he's not going to be about it in jail for a long time to be able to own a weapon. He had to have his DNA extracted, and he's not to have any contact with the family of the victim. Again, we've seen in our own region here, a couple of very severe cases in the last year. A Mississauga man charged in the spring, who, similar to Miss August, was using Kijiji to purchase puppies, mutilate them, and then releasing them into the community. His trial date has not yet been set. And again, over the summer, we had a very disturbing incident on an equine boarding facility in Welland, where several horses were killed. One was killed, and 8 additional horses were injured severely. That investigation is ongoing, and there has not yet been anyone charged with that incident. So these issues are among us at all times. We know, I think, that legislative reform is needed, but it is complex because of the way that we've developed these laws in Canada. We know that there are gaps in protection and that the pace of change in legislative reform is unfortunately quite slow. It's fairly well known among animal advocacy organizations like the CVMA and Humane Canada that animal welfare legislation is one of the most contentious pieces of legislation that comes into the legislature because of the farming lobby, the fishing lobby, the hunting lobby, who all don't necessarily understand the importance of working collaboratively with people to ensure good animal welfare. So what I really wanted to highlight during this talk is that through education, through networking, through collaboration, the various components of the criminal justice system, including veterinarians, animal welfare scientists, and others, have a really critical role to be working together collaboratively to use the existing laws that we have. I've tried to highlight how effectively those laws can be used to achieve important precedent-setting punishments, which we hope will act as deterrents for future individuals. Again, highlights that there's a lot that we can do in the meantime while we're waiting for that legislative change to alter the landscape of animal welfare in Canada. If you're interested in more of the work that I've been doing, again, feel free to visit my website and make that information aware to others who may need that information if they're needing assistance in investigation or considering the possibility of animal cruelty or animal maltreatment. And I'm happy to answer any questions people may have.